I applied for a visitor's visa back in my country.
Right.
And however, I stated on the form that I was in a common law marriage. However, I came here in the U.S. and I overstayed. One of my kids filed for me and got everything started to work. And then a couple months after, they called in for an interview and they asked if I am married. And I said no. And they keep asking the question and I said no. So they said, well, it's on my visa form. However, they denied me of my green card. They said I should file a waiver form, which is the I-601. We did, and they denied that as well.
Well, you can't file a waiver. This is what happened. When you got your visa, you probably, or I don't know if you did it or the travel agency did it, but on your visa application, you claim married when you were single. And people do that to try to get a visa because the visa denial rate for single people is greater than the visa denial rate for married people. And the reason is that a married person has more of a reason to return to their home country to be with their spouse. So when you filed your adjustment, you said single, and then they looked up on your visa application, you were married. And they said, okay, now you lied. But if you're being filed for by your children, there is no waiver for that. You could only get a waiver through parents or a spouse. Do you have parents or a spouse in the United States?
No.
Okay. So then, unfortunately, you can't get a waiver. So either you have one of two choices. You can, in the future, get married to a U.S. citizen to get your green card and file a waiver. Or you can argue, I never lied. I did not make a misrepresentation. I don't know what that argument would look like because I would have to go look through your paperwork, but those are your options. You probably should use a lawyer at this point. Okay, hold on one second.